When we're creating an estate plan, a topic that will come up is the involvement or interest that may be given to our in-laws, whether it's our son or daughter-in-law or stepchildren or the like, maybe even our child's in-laws, right? Estate planning is meant to subtract by addition. And so we're trying to promote certain beneficiaries and remove others by not naming them. Generally, when we leave assets to a child through inheritance, a will or a trust or beneficiary designations, those are treated as separate assets, separate property from a divorce standpoint. So they're attributed individually to the child's spouse, not as marital assets or community property to the marriage itself. It's just that it only stays that way to the extent it stays separate. Separate property is a divorce term. And so when we inherit property from our parents, it is separate if we do get divorced later, meaning it can't be subject to division under a divorce proceeding. But separate property is not an inheritance term. And so sometimes assets left to a child could inadvertently make their way into an in-law's hands through the death of the child. And so estate planning can be the effort to promote a reality where assets flow down bloodline and not become involved in any sort of inheritance to an in-law, right? The spouse of a child. We do that through trust planning, and we do that through holding assets in trust for the life of the child to make sure that they don't become individually owned, still benefiting the child, not precluding their use or enjoyment, but making sure that it doesn't become individually owned so that it wouldn't be susceptible to divorce or inheritance by the other spouse. All of it flows down the bloodline, ultimately to grandkids, great grandkids, and the like.